Hi everyone, welcome back to our second ever vlog. My name is Sabrina Ojla.
Hi, and I'm Rick Bikram. What are we talking about today, Sabrina?
So today I thought it'd be fun to talk about Ademption. I think it'd be really beneficial to all our users because it kind of seems like something that is pretty common, but something most people don't know about.
Yeah, so maybe I'll start off by explaining what ademption is. It sounds like a really fancy legal word. Ademption really occurs when there's an identifiable piece of property, something specific that a testator describes in his or her will with specific particulars behind it so that it is distinguishable from his or her general estate. And a gift under a will is said to have a deemed when that specific property does not exist. So, for instance, if I own Blackacre, the parcel of land called Blackacre, and prior to my passing, I decide to sell Blackacre and I take the proceeds of sale and I mix it into my bank accounts. And during the course of my lifetime, that money's gone. The property is said to have deemed, which is just a fancy word for saying that the gift fails. Now, provinces across this country have enacted different types of anti-ademption legislation. We're going to talk briefly about that today, but in Ontario, we have Section 20, subsection 2 of the Succession Law Reform Act, which speaks to the exceptions of ademption, as well as Section 36 of the Substitute Decisions Act in Ontario. Now, for those of you familiar with the Substitute Decisions Act, the Substitute Decisions Act governs powers of attorney and guardians. If you think about it, it makes sense. The Substitute Decisions Act governs substitute decision makers. Section 36 of the Substitute Decisions Act really just says that if an attorney disposes of property while someone may or may not be incapable, but the power of attorney disposes of the asset, then the person who would have been otherwise entitled to the gift may be entitled to a value equivalent to the gift from the general residue of the estate. And that really is the principle of ademption, and that is one of the exceptions towards the ademption rule. Perhaps Sabrina can take us through it. Have you read a decision recently on ademption, Sabrina?
Yep, so I actually took a look at the McDougall estate and Gooderham, I believe it's how you say it. So essentially what happened there is the deceased, she was a wealthy lady. She had multiple properties, and when she made up her will, she wanted a specific property to go to her sister. So the property in question was, we'll call it the Palm Beach property. So in her will, she said, the Palm Beach property owned by me will go to my sister upon her death. So as the lady aged, she lacked testamentary capacities. So her power of attorney essentially had to come into play. And it's got to be noted that that Palm Beach property wasn't owned by the lady herself, but was owned by a corporation in which she owned shares in. So essentially, when she started lacking testamentary capacity, her powers of attorney, who are also directors and officers of the Palm Beach Corporation, sorry, those who owned the Palm Beach Corporation, they became her power of attorneys. And essentially, it got to the point where they needed to determine if they should sell the Palm Beach property. I believe it was about in 3 years just to even maintain the property. It was about $1 million. And essentially, they came back and they were like, we need to sell this property to make sure that we can take care of her.
I
And so
believe.
they did.
Sorry,
Sorry?
I don't mean to cut you off, but I believe that in that decision, it was a situation where she was the testator in hand. She became incapable. It wasn't that she lacked testamentary capacity. She became incapable, which triggered the power of attorney. And then they were looking at her assets and they said, hey, we're going to have a cash flow problem here. Like she
Yeah.
was land rich, but cash poor. So
Yeah.
the powers of attorney, speaking amongst themselves, said to themselves, okay, we got to liquidate some assets in order to provide enough financial resources for her care, something along those lines.
Yep, nope, you nailed it. Yep, that was actually in the case itself that she was asset rich but cash poor. So they ultimately did sell the Palm Beach property. And upon her death, essentially, her sister was like, well, that property was supposed to come to me. what now? And here they relied on the anti-ademption rule. And the judge essentially said, so when you're looking at section 36.1, it talks about the property must be owned by, it doesn't say personally owned, it doesn't say who it can be owned by, it just says property. So in that case, just because it was owned by a corporation, it didn't matter because the deceased still owned the shares. And in her will, this is where it comes back into play, where she specifically said the Palm Beach property owned by me. So the judge here, sorry?
No, I thought it was a pretty creative argument. And I thought the judge did a really good job of getting to the point and making a common sense decision on it. And just to conclude, just there are things that estate planners can do, as well as lawyers who are assisting clients in the administration of the estate when it comes to the rule of ademption or the doctrine of ademption, which is really canvass with your client what happens if the gift doesn't exist on your death. Because even in the Succession Law Reform Act under Section 20, it says unless a contrary intention appears in the will. So you could technically get around, like you could have the issue of ademption addressed directly in the estate document. If and it's up to the testator. Maybe the testator wants the gift to a deed. So maybe he says, hey, the doctrine of ademption is applicable. Or maybe he doesn't, he or she doesn't. Maybe he or she says, the person will get a corresponding value from the general residue of my estate or whatever the case may be. But, that's really a decision for the testator. There's also a fantastic decision. It's a 21 decision. It's Best versus Hendry. And I'm going to have the citation for you below here. But in this decision, it touches briefly on solicitor negligence here, where a solicitor was assisting clients with respect to the administration of the estate and during the course of the powers of attorney acting and selling properties. One of the biggest mistakes they made was they didn't separate the proceeds of property that was specifically gifted to someone. And what happened was they commingled the money. And then the lawyer didn't give advice specifically on the rules of ademption. And ultimately there's a Court of Appeal decision out there that held that the solicitor was negligent, and it's a fantastic decision. I'll let you read it. You'll see the citation below. And that concludes our vlog for today. Thank you, Sabrina, for your help.
Thank you, Rick.
And we look forward to speaking to you on more decisions in the world of estates, trusts, and family law. Take care.